When does a parody of someone else's material infringe on their copyright? Hi, I'm attorney Gordon Firemark, and this is Asked and Answered, where I answer your entertainment law questions to help you take care of your career and business and take things to the next level. So a reader of the blog wrote in a while back with a question, when does a parody of someone else's material infringe on their copyright? For instance, having a character use the Vulcan mind meld in your story, changing some content within a Dr. Seuss story to create new characters, but keeping the same meter and structure and rhyme, changing a word in a famous slogan to reinvent it, using your own artwork that mimics someone else's artwork, but altering the actual content. Well, the answer to this question is both simple and very complicated. Simply put, if a new work copies the work of someone else, it infringes the copyright in that work. But in the US, under the First Amendment protections for free speech, the fact that it's a parody can immunize the creator from liability. The more complicated answer depends on the distinction between parody and satire. According to our good friend Wikipedia, a parody is a work created to mock, comment on, or make fun at an original work, its subject, author, style, or some other target by means of humorous, satiric, or ironic imitation. Parody is protected as a form of fair use, a defense to claims of copyright infringement. Cases dealing with this issue, however, look to how much of the original work is taken, holding that only that minimum amount necessary to conjure up the original work can be taken. But if that's the situation, parody acts like a bit of a shortcut to the conclusion of fair use, and we don't spend a lot of time and energy on the full analysis of the four fair use factors. Courts have also held that the parody work must actually make fun of the original work and or its author, not just a changed lyric for the sake of being funny about other things. Satire, again according to Wikipedia, is primarily a literary genre or form in which vices, follies, abuses, and shortcomings are held up to ridicule, ideally with the intent of shaming individuals or society itself into improving. Typically, a satire pokes fun at larger issues rather than the original work or its author. Now, satire is not automatically considered fair use the way parody is when it's a copy of an earlier work. It has to undergo that full four-factor analysis to make that determination. But before you go out and create your next great parody, you also need to know that where famous slogans and brands are involved, even a parody may not be a complete defense to a lawsuit brought for dilution or disparagement of a trademark. So you'd be really wise to consult an experienced entertainment or intellectual property lawyer with your specific situation before publishing. Now, if you have a question you'd like to see here on Asked and Answered, please visit firemark.com/questions and let me know. I'll see you next time.